type of traits are required in an individual so that he can excel in that career. So on those lines, I would be discussing about how he can and what are the companies basically where somebody can pursue his career, specifically in India. The second topic would be developing patenting ecosystem in universities. So I would be sharing some points basically which are useful for a university to think upon and develop a patenting ecosystem in universities, because currently in India many universities are not developing a patenting ecosystem or a framework which basically kind of automates a lot of things and encourages students, faculties to file patent applications. And as we have recently seen that India's rank in innovation index has jumped to 48 now. I mean, it's a very good improvement, and one of the main reason for that is Indian Patent Office also has shown a drastic improvement in the way things are being done now. The overall turnaround time of proceeding with a patent application has reduced significantly. Even the workforce in the patent office has significantly increased. So a lot of things are happening in Indian Patent Office also, which has contributed to increase India's rank in innovation. And therefore, it is universities could be the main driver of increasing it further. And the last topic, if we are left with some time, would be I'll discuss some examples about failed attempts to get patents. So in the previous session, I discussed some ideas which are like useless ideas on which somebody has filed patent applications. Just to bring up the fact that all filing or all patent applications which are filed in patent office are not valuable, and a patent is only valuable if it is granted. So in this set of examples, I'll discuss some specific examples of ideas which were technical in nature. People thought that they might get a patent on it, but eventually they were rejected. And then if some time is left, then we'll have a question and answers. So switching to the first agenda, which is like if somebody has to build his career in IP. So in the previous session, I discussed certain points like what are the basic characteristics which should be there in an individual if he has to develop a career in field of IP and has to do good in this field. So basically, like I discussed about that, if somebody loves to read, he loves to write. So these are basic requirements if you want to pursue your career in field of intellectual property. Individual needs to read a lot of research paper, a lot of patent applications. In a day, sometimes an individual needs to analyze almost 100 patents, even in some cases. So he must be a very avid reader. He should be a good writer, because ultimately the deliverables which are being prepared, out of the analysis which somebody does, you have to write, and these are generally in form of reports. It could be a PowerPoint presentation, it could be a Word document report. So somebody should be good in writing and articulating things in a very crisp and very concise manner, so that somebody who reads on those things, they can take quick decisions based on whatever conclusions has been provided. Then again, some points were like that, because you when you talk about patents, you are talking about technology. You are dealing in day out with what is developed, what is there currently in the technology field, and what are the latest developments, what are the emerging technologies. So he should be a tech savvy person. He or she should be a person who loves to read about technology. So I think I already discussed these points in the previous session. In addition to these, I would just want to bring up certain points which are like the candidate should have a very strong knowledge of the fundamental core subjects of their respective engineering courses. If it is there, then it really helps out a student to do good in this field of career. So as an example, if you are a computer science engineering student, at least you should be very good in understanding the fundamentals or core concepts of subjects like data structures, operating system, computer networks, computer architecture, microprocessors and controllers. Similarly, if you are an electronics engineering student, then you should be good in understanding communication systems, telecommunication standards. These are just example of some of the fundamental subjects, the core subjects which are there in any engineering course. So these subjects somebody should be really good at, because a job of a person who is working in the field of patents is majorly to interact with people who
Robotical market where? Market.
uh, to interact with people who are majorly working on cutting edge technology, who are working on things which would come in future. So those are generally very sort of senior and highly technical people who are fellows or architects in their field, and they are generally very busy. I'm talking about inventors. I'm talking about, in companies where people are very high end lawyers. So you need to basically understand the technology very quickly in very less amount of time because of the shortage, and then act accordingly. So it is very much required that a student should have a very strong fundamental knowledge of these subjects. Like similarly, for a mechanical student, he should have good knowledge about robotics, kinematics, thermodynamics, mechanics of solid, and these subjects. You may not have a decent knowledge about any programming language, but at least for a computer science student, it would be really required if he should have strong knowledge of the fundamental subjects. Then these are certain characteristics, I would say, or nature of the work when if somebody is working in the field of intellectual property. So I would say 70% of the job is purely technical. You have to understand technology, you have to analyze, you have to identify the differences between two different technical topics. Sometimes you have to do a tear down analysis of how a product is working. You have to understand what are all different hardware components in a product. You have to understand what are all different software modules in a product, how they are interacting, and all those things. Even you have to understand the architecture of how they have developed a computing system. So 70% of the job is technical, but 30% of the job, I would say, is legal. And this is just not a very accurate estimation. This is just a sort of a rough estimation that how much technical part is there and how much legal part is there. Legal knowledge is generally something which people learn over a period of time when they work on the projects. So there are a lot of there are a lot of laws. As an example, in the previous session, we discussed about what is not patentable. So each and that is a law from a patent act. So each section of that act has its own interpretations, has its own set of rules. Sometimes you have to read case laws. You have to read what are judgments which are being passed by High Court or Supreme Court, and how they have interpreted our technology when it comes to patenting something. So 30% of the job is legal, I would say. And this legal 30% part is generally something which people learn over a period of time, and they sometimes many people who pursue their career in engineering, they also pursue LLB later on, or LLM, or even sometimes from foreign universities they do their JDs and courses, so that they get more hold on the legal aspects also. And then certain characteristics of the job are that you should have an ability to basically think critically, strategically. A lot of time the projects are directly aligned with what the business of a company is. What is the business strategy of a company? So you need to be very much aware about what is the business model for different companies. If there are different companies like Microsoft, Apple, Facebook, what is their philosophy, what is their product line, what are they working on currently, what were their recent acquisitions and mergers. These kind of avid reading of technology and companies is generally required in this field. Also you should be able to so like for software engineers, you should be able to do a little bit of reverse engineering. You should be able to do a source code analysis. Many at times, if you are working for a company and you have to identify that if some of our patents which are being assigned to that company are actually valuable, so that you can go and sue some other company, and you are not able to identify if the software produced by that company is actually infringing on your patent. So you need to get access to the source code of those products or solutions, and do a reverse engineering or a source code level analysis to identify how that product is working. uh, in terms of hardware related solutions, sometimes a tear down analysis is required. So for example, if a company X is has some set of patents which are talking about a hardware device, for example a printer, and they want to see if their competitors who are basically killing their market are using their patented technology. So what they would do is they would hire somebody who can, who can basically perform a tear down analysis of a printer which is being produced by another company. So this is just an example. There are many more such examples where an individual is required to just completely sort of see a product from an exploded view, so, sort of a thing. So he needs to basically open up all the components of the product and see how that product is assembled, what are components that product is having, and what all functionalities that product is doing. Apart from that, a person needs to be a good planner, because apart from the usual project deadlines which are there in every industry, uh, in particularly in field of patents, there are a lot of legal timelines which are set by patent offices. So you need to abide by those timelines, otherwise there could be consequences. So if I miss out a timeline which is being set off, let's suppose, by a patent office, then it may also lead up to I losing of all my rights on that patent application, or my idea being dropped by the patent office to get a patent grant. So there are a lot of timelines which are generally there, and which are statutory or legal timelines which has to be followed. So an individual needs to switch between multiple projects, switch between multiple deadlines, and perform a very good time management. So this is another trait or a nature of work which is there in IP field. Then he needs to be a team player. He needs to be a very good coordinator and sort of an adapter, because a person who is working in the field of intellectual property or patents, his job is also to interact with a lot of people. And when I say a lot of people, I talk about his stakeholders, which could be lawyers, which could be senior attorneys, which could be people who are sitting across geographies, because generally in big companies, any product, teams sit globally, and there is a difference in the time zones. So sometimes, if let's suppose if I am working on any project, so many times it may so happen that the inventors of that that project, or engineering team of that project, is sitting in South Korea, or let's suppose it's sitting in China or in US. So there are a lot of time level barriers, like there are different basically clocks for each country, and then even language barrier is also there. So you get limited time to interact with people, and then you have to get all the information from them. uh, so uh, so it is very much required that somebody is very much good in coordinating and basically doing his communication very clearly and concisely. So as an example, I can say that suppose if I am working on a project which it requires me to interact with two engineering teams, one sitting in Singapore and one sitting in, let's suppose, West Coast. So I have to do my work in a time period which suits so that I can get information from Singapore team, and then do my analysis, and then interact with the team which is on the West Coast, and then also interact with lawyers or attorneys who may be sitting in US. So there is a limited time which is available, within which you have to get all the information and do quick analysis, and then provide our insights in a very clear and concise way. The last, I think, trait and the nature of work is that an individual should be very good in arguing with facts, and should be able to convince individual. So, for example, if we talk about, we file patent applications in patent offices. So many a times when your patent case is being examined by a patent examiner, he or she may say that your idea, or whatever algorithm or whatever technology you are trying to patent, is already available in some of the research papers or some of the previously filed patent application. Then a job of person who is handling that case in the patent office is to convince that examiner with some facts and logics that there is a technical difference between what I am trying to patent and what is already described in the in the documents. And this is just one example. Sometimes this arguments and fact presentation and convincing power is required when you are trying to present your report in front of business leaders also. So suppose if a company is planning to acquire or merge a smaller company, and they want from IP team, people who are working in intellectual property division of that company, an insight about how good is the intellectual property or patent portfolio for that company which we are trying to acquire. So the IP team generally presents a report to the business heads of that company, and it requires you to basically convince them that from IP front things are good or things are bad. So a lot of arguments with facts and convincing, similar to what lawyers do, is also required in this field of area. I think one thing which I would also want to mention is that an individual who is working in field of patents and intellectual property, he may have to switch between different technology domains within a very short span of time. So because generally teams which work on patents or intellectual property field are sort of COEs within an organization. They are like a central team within an organization, and a product company or a solution company may be working in very variety of technologies. So every idea or every thing which is related to patent comes to that central team. So it may be required for an individual to switch between different technical areas within a very lesser span of time. So that ability should also be there. Unlike if you are in a software development company, or you are doing some you are in some VLSI based company, you are working on a constantly, at least for a year or two, or on a platform or a technology. So that is a difference in the nature of the job, I would say. I think somebody has raised the hand. I would say that please note down your questions. I'll take up all the questions towards the end of this session. uh, and then apart from switching between variety of technology verticals, somebody may also need to switch between dedicated business verticals. So let's suppose if an individual is working on a company which produces printers, and that company is also into field of networking, providing network gateways, switches, different other solutions. So it may so happen that he's working within one business vertical which may operate entirely in a different way, and then after working for a span of 8 to 10 months, he may have to switch to another business vertical because the requirement over there would be more, and he may have to switch from a technology front also, and even in terms of different processes or different way that business operates. So that is also sometimes required. So these are the basic traits or the nature of work which is there in the field of intellectual property. Now, this is a very interesting timeline, I think, which people should see, and they can get to know how a team or an intellectual property team contributes in a product company. So the central timeline, I mean, the central line which you can see over here in blue color, is nothing but how a product is generally developed. It's a general timeline, phase gate timeline of developing a product in a industry. So if you generally know, like, the first phase is where different marketing leaders, they go into the industry, they ask customers about their requirements, basically the requirement gathering part, which generally is required. And the company basically thinks of what all are the areas where we can develop something, where we can offer a solution to a customer. That is the first phase. And then after gathering all those requirements, customers VOCs, and then getting all the business requirements, internally the company analyzes that, okay, we would be investing this much amount of our resources in terms of money and R&D in developing some solutions on a selected business vertical. And then the company generally develops some sort of, they gather all the requirements from a customer, and then they develop a prototype or an initial level architecture of a solution, and then they showcase it to a customer. The next step is generally, the full product or a solution is being developed, and then after that, testing of the product is done. There are different type of testing which is done for a product, and then some beta release kind of a thing would happen, where the product is being released to the customers for their own testing or integration on their own infrastructure or platforms, and then eventually the product is released in the market. And then after the product is released, the next phase could be that you may need to support the maintenance or constant improvement within that product. So this is a general product development timeline, and how patent teams contribute at each phase of these product development timeline is being showcased in the top timeline and the bottom timeline, which is listed over here. So When I talk about the customers interacting with the marketing leaders, interacting with different customers, gathering their requirements, and then finding out what the company should develop, the patent team basically helps the engineering team to do a wide space kind of an analysis or a technology landscaping analysis. So I would share one example of such a report, which generally is being provided to business heads or engineering teams in those lines. So the objective of this analysis is to basically uh, it could be there could be two objectives. First is the team would basically explore a particular technology area and see what is the state of art in that technological area, how many patents are filed, what kind of patents are being filed, which are the main companies who are filing patent applications on those lines, what are the products that they have, and then try to come up with some gray areas or white areas which nobody has explored so far. And then these areas are something which are identified and explored on further by the business teams to think of certain solutions which the team can develop. On the other hand, many companies they promote individual inventors to submit ideas, and generally, let's suppose if a company has an engineering team of 500 engineers, they submit a lot of ideas which are mostly driven by their day-to-day, working with the projects which are related to that company. So they would be working on some sort of solution, certain certain products or certain things to which they are associated with. So the ideas are also generally linked to those products or those things on which they are working, and they submit a lot of ideas. So I mean, it may so happen that they submit 1,500 to 2,000 ideas, for which collectively, for which a company has to decide that how many of these ideas are worth for a patent filing. So the IP team helps in doing a pre-screening of those ideas and doing innovation mining, and then basically suggesting, even coordinating with the engineering teams to tell them that we already have some good patent portfolio on these type of ideas. So encouraging them to submit some ideas on those lines, and some in some situations even guiding them on topics on which they should submit the ideas, so as to build a good patent portfolio for their company. The other part on the I'll discuss the top timeline first. The could be once the company basically defines or starts building up a prototype or an architecture for the thing which they have finalized, and by that time certain ideas which are being selected or which are there to be coming up in that product are being finalized by the engineering teams and the IP team. So the IP team then perform patentability searches on those ideas. These searches are generally performed to see if already some patents or if already some documentation is existing which could pose a challenge, if a patent is being filed at the patent office. So that is basically the job which is done by the IP team at that point of time, to give a sort of a guidance whether it would be good to actually file a patent application on this idea or not. That is the outcome of a patentability search. I'll pause here for a minute. I think there are some questions, if it is.
Yet not Sparsh in a question answer section. I have been sharing it with attendees that you do post your questions in question and answer session. So we shall continue, I think.
All right. So once the patentability searches are being done, so assume that 1,500 ideas were submitted, and out of that 100 ideas were there which a company decides that we should go ahead and file a patent application on these 100 ideas. So and then out of those 100 ideas, the team performs patentability search, and based on their analysis, they think that out of this 50 ideas would be only worth patent filing, because the rest of the 50 ideas may get rejected. So now you have a filtered set of, let's suppose, 40 ideas or 50 ideas on which actually somebody would start development on a patent application. So that is the next step in this field, which is like the actual preparation of a patent description, preparation of a patent application, which is also called as patent drafting. Now, any patent which is being drafted is to be drafted and filed in a patent office before any release or any beta release of a product out in the market, so as to secure your patent rights. So again, there are timelines which are associated with different things, and the whole process of patent development goes parallelly along with the product development. And then once a product is being released, so let's suppose the company developed a camera and they released the camera in the market with certain fancy features. It may so happen that a customer would say that, okay, the next version of that camera which you would release should have 2 more features which are more valuable. Which were not previously there in the previous cameras. So the team would, along with developing those 2 additional features in that camera, the patent team would also want to cover those additional 2 features if they have filed some patent applications on the previous camera idea. So they would build a patent family on those to cover those additional features which could be filed in a patent application. So it is not just like one patent is being filed for an idea. Sometimes for an idea there could be a family of patents which are being filed to claim that idea from different ends, from different perspectives. And then eventually, during the product maintenance and continual support, sometimes there are certain changes which are required to be done in the product, which could be improvements in the product. So sometimes for those improvements also, patents are being filed. So a constant support from the patent team is also required. And I think the last phase could be like once you have you have released the product in the market. Now, assume after 2 years, the product was doing very good in the market, and you were generating a lot of revenue out of that product. But suddenly a company realizes that there is a competitor who is sort of selling a very similar product in the market, and he's cutting out your business. So there might be a possibility that that competitor is copying your technology, but because you have filed patent applications on that technology, so the next step which you would do is go for patent enforcement or licensing. So what the IP team would, or the patent team would do in that case is, they would receive such requests from marketing leaders or engineering leaders from a product based company, that we launched this product and it was doing good for 3 years. We collected this much amount of revenue for these 3 years, but suddenly in the 4th year, another competitor has come up and he has started selling a very similar product, and we think that he is copying our technology. So at that point of time, the patent team would basically see that whether the patents which we filed at that point of time when we released that product are actually can be used to license for that competitor, or file an enforcement suit case against that competitor and stop them for selling their product, or basically ask them to pay the licensing fees and earn royalties from that. So that is how the top timeline of the patent building activity or a patent acquisition activity would go hand in hand in parallel with the product development. The bottom timeline, if you see, it is basically like when any company is planning to launch a product, they would also want to make sure that if they launch out anything or any functionality in a product, that functionality should not be taught by somebody else's patent. So they also want to launch everything, like big companies, Google, Microsoft, Apple. Whenever they launch any product, they also want to be very much sure of that whatever they are launching in the market should not infringe on patent rights of somebody else, because otherwise they would face a patent infringement suit from that company, and it harms the reputation of that company a lot. So that is the bottom channel basically describes what all things a company generally do to basically protect themselves and make sure that whatever they are launching in market is risk free. So then the patent team, an individual who is working with a patent team, what he would do is he would perform a freedom to operate search or an IP clearance search. Now, what a freedom to operate search is nothing but that individual would list out all the features or components or software, or algorithms, whatever is there in that product, and he would see what all existing patents or granted patents are already there in the market, which are very similar to what we are planning to launch in the market. So it may so happen that a company has planned to release 10 new features in a camera, but those 10 new features are actually very similar to a patented technology of a third party, not that company. So then this search is being conducted, and then it's like a risk mitigation activity where the patent team basically analyze all those patents which are very similar to those features. They see whether if we will launch these features in the market, whether we would be infringing on their patents. And sometimes it may so require that based on the inputs from the patent team, the engineering team have to do some level of changes in their code, changes in their component design, and even sometimes certain functionalities are there which are just dropped off So it may so happen that a patent team may conduct a risk assessment on the product which is being launched, and by performing a patent, a freedom to operate search or IP clearance search, the patent team finds out that out of 10 functionality which you are planning to launch, 3 are something which we cannot launch because there are some patents which are existing with our competitor, and in past we have also had some fight in terms of patent with that competitor. So the patent team may stop the release of those 3 features in the product. And then I think the next part is providing sign-offs. So whenever a product is being launched in big companies, generally the patent team, they give sign-offs from IP side that okay, everything is fine, you can release the product in market. There would not be any challenge from intellectual property front or patenting front. Or in terms of that, we have also filed patent applications on the ideas which you are trying to launch or release in a product. So from both the ends, like from the top channel end and the bottom channel end, sign-offs from patent teams are generally required whenever a product is being launched. So this is a general timeline of how a patent team supports in a product company. And I think patent teams are also there in service industries. So in service industries, they basically do the task what a product company patent team should have done. So that things remain same, but the only thing is that all of these activities or some of these activities are outsourced to the service companies or law firms which work on these projects. So I'll just pause for a minute and I'll show you an example of a report which can be prepared by a patent team. So that so this is a report which was publicly available from NASCOM, and this is a kind of a deliverable which a person who works in patent team has to prepare. So he has to go through a lot of data analysis, extract patents from patent databases. Companies have huge patent portfolios. So like, for example, IBM has almost, I think 60,000 plus patents, and they are from almost 150 plus different technology areas. So they have to do a lot of, the patent team has to do a lot of analysis from the data and come up with certain insights. So this is an example of a patent landscape report in field of Internet of Things, which I think NASCOM has prepared. So I'm just giving you, showing you this as an example of what is an end product which can be provided by a patent team to the business heads of the company. So if you see, this has a lot of analysis or insights about particularly IoT related technology, and they have identified what are how much patent filing has been done over a period of years, what is the distribution of patents in different countries, and then how many patents are being filed in IoT by MNCs, by universities, by individual inventors. And even there is a very this is just an initial level of analysis. Sometimes this goes to almost 200 such different insights which could be provided to the business heads or heads of a company, so that they can take strategic decisions whether a company has to invest R&D in a particular area or not, because everything requires a lot of cost. So whenever a company does its financial planning, they rely on these reports to chalk out whether they have to actually invest that much amount of money or billions of dollars in doing some R&D on these specific areas. So this is just one example. Just wanted to showcase what is an end product look like which a patent person would be working on. So like if you see, they have identified in this report certain companies which are startups who have done really commendable job in IoTs, and these insights require a lot of business analysis, competitive analysis, and a lot of reading and then interpreting a lot of data, and then finally coming up with conclusions which could be provided as insights. So this is just one example, and I think the another example I'll just also show. Yeah, so this is again, just an example which is available in public domain, which is again a report by, I think, NASCOM on the emerging technologies. So they also have, so a similar job is being done when a patent team performs a landscape or a technological, technology landscape to basically come up with areas which are promising. So this is another sort of a report which is being generated by an individual who is working in field of patents. So you can see that there are a lot of insights which somebody has to present. So like if you are working in field of patents, the job is not just to simply prepare a patent application. That is just one part of a job, or do a search. That is just one part of a job. I mean, the bigger projects are like this is one such example where the company is going to rely on this report or whatever insights you have provided to take a final decision, whether they would be investing some $1 billion or not in some field of areas. And then from there, that investment, everything starts. The product development start, hiring of resources start. So a lot of things depend on these insights which are being provided by a patent team. Then this is just an example to show, obviously like a job of a person who is working on patent is to prepare a patent application. So this is just an example of a patent application which somebody would have prepared. So he needs to basically understand from inventor what is the technology like, and then prepare these drawings. These are some more technical drawings. So like, this is an example of a warehouse where robots are being used to basically it is an example of an inventory where robots are basically assisting individuals to do automated operations of picking items for an order and then placing it. And then these robots are remotely connected to a database also to basically do real time inventory management. So you need to prepare these patent description, and this is another end deliverable of a person who is working in field of patenting. And as an example, as I told you, like just if you just see this example, this involves amalgamation of many technologies. So like you have mechanical components working here, you have cameras, and some at the back end some image processing would be happening. So you may need to describe all of it in a patent application when you write a patent application. So it may require switching between different type of technical field areas and writing it in a way so that it is very much clearly understandable by the different individuals, even by the patent office. So that is also a type of job which a patent attorney or a patent professional has to do. So these were just only some examples. There are a lot of projects, there are some 20-30 type of different projects. I just picked up certain examples so that and a student can actually visualize what is the end deliverable that he may need to prepare. Okay. And this is basically a career path. If somebody has to grow in field of intellectual property, then what would be his job roles and what are the requirements from him? So I mean, just to quickly browse you, I mean, all of people through this. As an entry level professional, people are generally called as patent analysts or patent engineers or patent associates. So these people, I mean, when a fresher or a candidate joins, completes his engineering and joins a service industry or a product company in field of patents, he generally works under extensive supervision of senior people. He's generally trained on very a lot of fundamental laws or legal things which are related to field of patents. He's generally being trained on how to use different patent databases and patent tools. So a lot of things are generally automated, and a lot of big patent databases are there, or very smart tools are there which are available, unlike similar to many cloud platforms, which you need to understand how these tools operate. So a significant training is required to work on those tools, and so that somebody can quickly extract all the patents which are there for a field of area and then analyze a particular patent portfolio. And then once you grow and in the organization, you are generally a mid-level professional. This is a designation which which changes. So you will become a senior patent analyst or a senior patent engineer or a senior IP engineer, and then you work under some level of supervision on some complex projects, and then you basically work on some big projects, which is like preparing landscape reports, which I just showed you. Independently doing certain things, and individually drafting patent applications, or performing clearance searches, which I described earlier. So all those project types are generally handled then individually by the individuals after they grow to this area. And then at some level, once you are a mid-level professional, then you would be required to interact with a lot of stakeholders, as I told you. Like you need to interact with a lot of patent attorneys, lawyers, senior people, who are fellows in companies, who are basically technology masters or subject matter experts of that field of area, and even with the engineering teams and inventors. And then you also may need to mentor junior people who are basically entry level professionals or new to the field of patents, on how to use different patent databases, how to basic fundamental laws of related to IP. And then you become, after a period of time, once you grow in this field of career, you become leads. So basically you are an experience level professional where you would independently handle a lot of projects without any supervision. You would basically support, so like big companies, they have different patent portfolios in different technological verticals. So let's suppose Microsoft as a company would have its business spread out in 15 different business divisions, and each of that business division would be then further divided into multiple technical verticals. Like one division could be related to user interface, one division could be related to gaming, one division could be related to developing cars. So each of that sub divisions would have a lot of engineering teams, and they would have a significant patent portfolio on that division. So big companies, they generally have patent portfolio managers who take care of that entire patent portfolio. They decide the strategy for that portfolio. They decide what type of patent applications we need in our patent portfolio. How can we use these patents against somebody? How can we license out these patents against somebody? So they take care of a patent portfolio, and they are called as patent portfolio managers. So and then leads generally assist them in developing the patent portfolios, and then eventually you become a patent portfolio manager and you take care of an entire patent portfolio of a division. So just to give you an example, let's suppose Apple, they are developing iPhones. So they would have a good patent portfolio on the design aspects of iPhone. So there would be a team who would solely work on the design related patents of Apple. And then there would be a portfolio manager who would take care of that, let's suppose 200 to 500 patents which fall under that portfolio. And this requires a lot of cost analysis also. He needs to, because managing 100 patents means that you are dealing with dollars or maybe sometimes $1 million. So in terms of filing of patent applications, maintaining them, and then so basically all these activities are being taken care by the patent portfolio managers. And then eventually, once you have 15 years of experience in the field of patents, so you become chief IP counsels, or you become HODs or directors in their specific division. So these people take very high level strategic decisions basically. So these people sort of take decisions which are basically they would interact with business heads of other divisions. So there would be a intellectual property head of a division who would interact with a marketing head of a division, and to give him his recommendation if a marketing team is deciding to basically develop a solution in some geography. Or he may also give him insight on whether a merger and acquisition should take place. Many a times companies, when they go ahead for mergers and acquisitions, they also see whether a company which we are trying to acquire, is there any active litigation suit which is going on? Is there any lawsuit which that company is facing currently? So that would be a negative point to invest in that company. So the final go ahead from the IP team is generally given by the HODs and directors and of that IP team. And then these HODs and directors, they also decide the patenting strategy, or what strategy should companies adapt in terms of their patent process. So certain companies are there which are very defensive. They do not actively file patent enforcement cases. They do not go into lawsuits. They do not monetize their patent portfolios very actively. On the other hand, there are certain companies who are very aggressive in monetizing their patent strategies. So what strategy suits a company according to its business model, that is being decided by the chief IP counsel or the HOD in that company. So this is just to give some insights of what is a career path or job roles and requirements of an individual who would be working in field of patents. This is an example of basically the companies which are there, which are basically active in India in doing work in field of intellectual property and patents. So you can majorly categorize the companies where students can go and pursue their career into three categories. One is the knowledge process outsourcing or legal process outsourcing type of companies, which you can say. These are service-based companies. They have big clients, like they have clients which are Fortune 500 companies or Fortune 100 companies, and they take care of a lot of work which is being outsourced by these companies to these service industries. So like CPA Global is one such company. They even provide a lot of products which are customized for patent portfolios. So they also have tools which can be used to search for patents. They also provide patent portfolio management tools which a company can use to manage their patent portfolio, to visualize all the timelines, to visualize all the cost which they have to incur, and take care of that entire portfolio. So these are some of the service based companies to which an individual can apply after he completes his graduation and work in these companies. And these are very big corporate companies, and they have a very extensive training routine. And generally, people who come out of their college, they generally join these companies. Like I myself joined CPA Global. And then the second category is law firms. So there are many good law firms in India. Their work is more, I would say, more legal in terms of they actually provide legal recommendations. If you want to learn good patent drafting, or if you want to learn how to provide an opinion of to a company of whether to go ahead with a IP clearance or not. As I told you, like if a company has to launch a product, they have to get a sign off from the IP team. So many a times, the companies don't want to take the risk of, or the business heads don't want to take the risk of giving a go ahead, to launch a product. So they rely on legal recommendations from, basically law firms. So there are a lot of law firms which an individual can join at an early stage of his career and become a proficient intellectual property lawyer and attorney. And not even these law firms are in India. Across world, there are many good law firms which are, and these law firms are particularly specific to patents. They hire engineers and they develop them in field of patenting, and then they also train them on legal aspects. So an individual comes, after 5 to 6 years of his career, he is more proficient legally also, and anyhow he would have worked on a lot of patent related projects. And then the third category is like in-house teams or product or service companies. So there are less product, because generally, the IP team in a product companies are generally situated at a headquarters of a lot of these companies. So there are lesser in-house teams in India, and but there are, and slowly it is developing. These teams generally hire experienced individuals. So typically in an in-house division, if you're going in an in-house division of a product-based company, it is equivalent to you are going into a very high-end team of that company, because you are directly into strategy. So they hire experienced individuals who have 4 to 5 years of experience in either a law firm or either in a service industry, and who have done remarkably good in their field of areas. And then these individuals can join these companies and directly work on the patent portfolio strategy as such, which I talked about previously. So like Microsoft has its big IP team, Honeywell has its IP team, Facebook, Mercedes, every company, any company who is working in R&D, they have their IP team, which is a very focused, centralized team who directly works on things which are related to strategy. The size of the teams are generally very small, like maybe 40 individuals, and those individuals are selected out of a lot of scrutiny. So and a lot of academic background is also seen sometimes. So this is the third category where individuals can approach and pursue their career in field of IP. So this is all about how you can pursue the career in field of IP. So that's about the first topic. I would now switch to the next topic, and I think this is a relatively shorter one, which is like how a university can develop its IP ecosystem. So there are certain points which I noted down based on my research, and I think these things are something which at a university level could be done. So like as per UGC norms, UGC recommends that university should have their intellectual property center, which have a focused group of focals or individuals, be it professors, be it academicians, be it industry experts, who basically take care of the entire patent filing or patent development process for that university. So, and apart from that, I have seen that, currently many universities in India, they do not have a very good framework for supporting and enabling, students to file patent applications or develop their patenting portfolio, or even, contribute to the field of intellectual properties. So certain universities have their invention, incubators or IP focals for Department of Technology Transfer, which is a dedicated focus department which takes care of all the activities which are related to patenting field. So I think that is something which any university can develop. Like I am aware of that CMU has its Department of Technology Transfer. They have a very good intellectual property center where they have individuals who are sometimes licensed patent professionals and industry experts who basically take care of the patenting curriculum of that university. The other point is that there could be just like there are many elective subjects which are being introduced in many universities where the student has an option to, along with working on his core subjects of a field of area, some of the elective subjects could be developed, or a course curriculum should be designed which are specific to topics related to patent. These subjects an individual can choose in their second year or third semester or fourth semester, and they can there could be credit focused subjects, and they can understand a lot of theoretical things, as well as do some practical workshops. A lot of projects could be converted in form of a workshop which or a lab exercise which somebody can conduct, so that they can develop some skill set which makes them suitable to go into the field of an IP. So some elective subjects could also be introduced in the universities. Then there could be yearly goals for faculty members, for students, for doing patent filing. So similar to many product-based companies, they have yearly goals or targets for engineers who work on that. You have to submit let's suppose 10 ideas, and out of which if 3 ideas of your submitted 10 ideas get eventually filed in terms of patent, and you get a patent grant, then you are rewarded with compensation. So similarly, there should be some yearly goals for faculty members and students to promote patent filing, and and year-on-year basis return of investments on those goals, or or those setups which our university can do could be evaluated, and then accordingly a patenting framework for that university could be customized and decided. So this could be another thing which university can do. Then a university can develop a specific patent filing process which is customized for that university per se. So every university has its own way of imparting education to the students. So they can have certain, I've seen certain universities which are purely theoretical based, which impart education which is purely theoretical based knowledge. There are many universities where a lot of project driven activities are being done, and students are actively working on live projects, developing prototypes, or even investing their efforts in developing ideas which could be for startups. So according to the requirements of that university, there could be a patent filing process which could be developed for that university, and then there could be an idea review committee. So there could be a committee which could be formed, which could include subject matter experts, experts who are in specific field of area. So for example, if a faculty or if a member has a mastery in one technology, so it could be a subject matter expert in that area. There could be licensed patent professionals also outside the university who could be engaged in, and in formulation of that committee, who can evaluate all the ideas which are being submitted by the students. So on one hand, students should be encouraged to submit a lot of ideas without thinking whether eventually it could be converted into a patent filing or not. But an evaluation of those ideas could be performed by the idea review committee, and a scorecard could be developed against each idea, and this could be done in a very transparent manner. So, and then based on that scorecard, and scorecard could be based on a lot of factors which which could be received from as an inputs from the subject matter experts, from the licensed patent professional. So, for example, a licensed patent professional could give his inputs, or he could give a set of factors which could be considered before going ahead and filing a patent application based on his expertise in laws, patent laws, and in field of patenting. And the subject matter can give his set of factors which could be based on his knowledge or his expertise in that field. So a subject matter expert could be can provide you a factor which could be like that this technology or this particular field of area is not very much promising, and there are not many industries who are working in this area. So all those factors could be correlated, and weightage could be given to all those factors to develop a final scorecard for which could provide a score for all the ideas which are being submitted by students. And then based on that, and there could be an exhaustive list of factors. I mean, I just gave some examples. And then based on that scorecards, it could be decided that what all patent, ideas, what all ideas could be actually converted into patent filing. And then the university can support students to, get those patents prepared and filing of those patent applications. Now I'll just quickly show you. There are a lot of, so these are the activities which generally could be done from a university administration point of view. But there are a lot of activities which even students, and faculty members can do by themselves without the involvement of, particularly administration part. So that is like there are a lot of courses which are available, which are being offered by US Patent Office, European Patent Office, Indian Patent Office, which are available online, and a student can enroll on these courses. So I'll just show you one example. So this is basically, if you can see on my screen, this is a page by United States Patent Office, and they have a lot of courses. They have a learning and resource center which have a lot of online courses, customized programs which are generally available for students and faculties, which they can do, and they can get certification, and they can learn a lot by doing these courses. Similarly, European Patent Office has a lot of courses. So if you can see on my screen, so see, this is a course which is called as From an Idea to Patent. So I think this course is about how, if you want to convert an idea to a patent in Europe, what all things may be required. So, and this is free of cost, and anybody can, any entry-level professional or an individual inventor can go and enroll for these courses and do these courses. Similarly, this is the World Intellectual Property Organization, WIPO. So WIPO has its academy, which is e-learning academy, and they have hundreds of courses in particularly patent-specific courses. Some of them are paid, some of them are freely available, and individuals can do these courses, get the certifications, to get themselves trained on certain topics which are related to patent. Even there are courses on patent drafting. Even there are courses on doing the landscaping kind of a project which I just illustrated previously. And even these academies have summer schools also. So they also offer summer schools where individual can go and join these academies and do enroll for a summer school program for 2 months or 3 months and get done with it. So this is from the students' perspective. And then there are certain things which I also want to share is like there are even encouragement which could be given by university for mandatory sort of ideas filing. Ideas filing means idea submission. I mean, the students who are working on third year or fourth year of, and they are working on major projects or minor projects, so they could basically submit their ideas for patent evaluation, and then their ideas could, separate credits could be rewarded to them if they submit good ideas and their ideas get converted into eventual patent filing. So some credits could be given to even promote and encourage students, or grades could be rewarded, extra grades could be rewarded to them to basically come up with valuable ideas which could be converted into a patent filing, and which could be lucrative for industries who can seek out to basically acquire those patents from the universities. Sometimes startups are very much interested in acquiring those patents. So those kind of ideas should be rewarded to in terms of providing good grades to students. And then there are some existing platforms also which encourages students and independent inventors who may not have all the resources or expertise to do patent filing. So I am at least aware of this, like these two platforms which are there in India. So like there is a Design in India by Qualcomm. So Qualcomm has a Design in India challenge kind of an activity which they conduct every year, and this is open for startups. So when you enroll for this activity, basically whatever idea you are developing as a startup, you share it with Qualcomm, and they support you in terms of development of that idea if your idea gets selected, and they do take care of all the patent filing preparation cost of that idea, and even the rights are given to you only. I mean, they don't even take the assignee rights of that those patents. They just are doing it to promote the innovation, and you also get some reward in monetary reward. So I think for startups there 2 lakh rupees or somehow compensation if your idea gets selected and you win in that idea, and they take care of all the patent filing procedure, every activity which a normal individual may not be aware of. So they have their own IP team who takes care of everything, and they promote it, and it's a platform which anybody can use. And then there is another idea like which is from Invent with Nokia. So Nokia also have a similar objective of promoting individuals to invent along with Nokia. So if you see on this page, you can visit this page, and this is like basically you can submit your idea, and you can register with the Nokia's innovation platform, and they would take care of the finances. They would take care of supporting your idea and getting it converted into a patent application. And then there are some non-profit organizations also, like ISERD. This organization, they conduct a lot of Olympiads, events, workshops, webinars. Like they conduct IPR Olympiad, to which the students can enroll, and they can develop some level of skill set, which can sort of look attractive to service industries who are in field of patents, and they can hire these individuals who have done some courses or work or attended those events. And I think the last thing would be that the students could be encouraged to participate in internship in IP industry during their 3rd year or 4th year of program. So there are a lot of programs which are being run, internship programs which are being run by the service industry. They look out for interns. Many law firms look out for interns. They hire interns, and then those interns are basically they offer paid internship, and during the internship the students are trained on live IP projects, live projects related to patent field. So they get expertise, or they get some level of expertise or skill set working on those projects, and this would also help students to evaluate whether they are really finding field of patents interesting for them. So their internship can also serve that purpose. Now, having said that, all these points, how to enable these points, I think that is the biggest challenge which many university faces. I mean, a lot of webinars or seminars are available online also, where these points are generally discussed upon. But I think this is my suggestion, which could be like there could be a digital framework which would be developed, which could be used by faculty members, students, and any stakeholder of the university to perform these activities. So it could be like a mobile application or a web service, which I think students of 4th year or 5th year can collaboratively develop, and this platform could be used for several purposes. Now, one of the use of this platform could be, so assume that you are an engineer and you are in your 2nd year, and you identified a problem. You identified that you were very much aware of what are the new features in a mobile device or a smartphone, and then you identified a problem and you felt like there is no solution which is existing to that problem. Now, one thing could be you either do not propose a solution, or maybe you don't know a solution to it. So this portal could be helpful for the students where technical problems could be submitted, and then these technical problems or specific to an industry or specific to a technology area could be visible to everybody. Anybody can, it's like an open source kind of a thing, like open source development people do, and anybody can contribute. So anybody can contribute with a solution for that specific problem statement. Now there could be access controls or multiple user-based accounts which could be there associated with that digital framework. So the solutions could be kept private. Only a faculty member maybe or only a mentor could see that solution and evaluate whether that solution is actually buildable and implementable. And out of those solutions, many ideas could be submitted. Like I mentioned, the idea submission forms. And they could the students could submit documents, PPTs, prototypes, for those ideas. And all the ideas could be collated on that platform. It could be a cloud-based platform. And then the same platform could be used by the idea review committee, which I mentioned, to basically, implement a framework and provide a score associated with individual ideas. And then everything could be done in a very transparent manner. So, even students or faculty members, they can see the progress of, their idea getting converted into a patent application and at which stage, your idea is currently in. And then these, the platform could have dashboards where, it could be seen that how many ideas are being submitted to a particular field of area. So how many ideas students from electronics department have submitted. Within electronic departments, how many ideas from a particular, subdivision of electronic departments, how many ideas they have submitted. So it could everything could be visualized on a dashboard, which could build up a competition to submit more ideas and more valuable ideas. So dashboards could also be to visualize that how many ideas are actually being converted into or have gone to the next stage of being evaluated and converted into a patent filing. So accordingly, activities could be monitored. And then apart from that, there could be news feeds and updates which are related to patent specific, which could be managed by the patent committees or IPC forums, who can constantly provide latest updates and news which are happening in field of patents or in technologies. Those could be like additional features to this platform. And then there could also be a job portal. So it could be like the placement coordinating team for that university could dedicatedly look for opportunities which are in field of patents, and they can post the jobs and listings on this portal, and then the student can apply for those jobs. So I think this could be a sort of a digital framework. I just like if JKLU wants to develop such a framework, I thought you can term it like invent with JKLU or any name, and I think this could be done to develop a patenting ecosystem or an IP ecosystem in the university. So I think this is on this part. So I think I'm done with the two of the topics. The third, I think I'm already running out of time, Sonal ma'am. So I apologize for running out of time, but I think the next, I'll just take 5 more minutes to cover the next.
Sure, Sparsh.
So these are some examples of, this is totally a different topic. So these are some examples of failed attempts to obtain a patent. So just read this claim. So it's a legal language. Patents have claims, and it is like writing technology in little bit of legal language. So certain things, certain words may be little strange, but just try to understand what they're trying to claim. So what they're trying to claim is they're trying to claim a paradigm for a marketing software, which would basically, it's like a methodology or something like, which a marketing company is trying to claim. So they're saying that there would be a marketing company that would market its software from different independent software companies, and basically carry out and pay operations associated with the marketing of that software from different companies, and in return of that payment they would get a share of total income from the individual marketing companies, while allowing the software companies to retain their autonomy. So it is nothing but kind of an intermediary service which they are trying to offer, where they can connect with different independent individual small companies who can do marketing of their product, and they can have their own autonomy, and then in return of that they would get some compensation. So it looks technical. If somebody would read it, it looks, at the face of it, it looks little technical. But it was rejected by United States, US Patent Office, because they said that paradigm is a business model, and business model as per US laws sometimes are not patentable. In India and Europe, it is a complete bar. You cannot file, you cannot get a patent. You can file, but you cannot get a patent on business models. So the US Patent Office rejected and said that your claim of patent is not falling under any of these categories. Like, it is not a process, it is not a machine. You have just trying to claim a business model, a paradigm. So you cannot get a patent on it. Now another good example, and this is I think more for computer science related people. So it is related to image processing thing. So just spend a couple of minutes to read this claim. So again, so this looks like very much technical, very much related to image processing. So basically, they are claiming a device profile which describes properties of a device in a digital image reproduction system. So and then they are saying that the profile could have a first type of data, it could have a second type of data. The first type of data would describe a device-dependent transformation of color information, and the second type of data would describe a device-dependent transformation of spatial information. So it looks technical, but it was rejected by patent office because the patent office thinks that the device profile is an intangible collection of information. It is what you're trying to claim is nothing but a collection of information or a collection of different type of data, and trying to say that what that data describes what. So this is not falling into any category of process machine. So that is why it was rejected by the now again, this is another very failed attempt to get a patent. So this is nothing but this is very simple. I'll read out it quickly for everybody to understand. This is a method for selecting an access network, any network from multiple networks which are available. So for example, if there is an RFID based network, if it's a Bluetooth based network, if it's a Wi-Fi based network, or many VPNs or LAN based networks, many selective networks are available. So basically, it is a technique for determining a radio quality from a terminal for each of that network, like what is the signal strength for that particular network, then determining what is the utilization factor for at each node, like how much network or bandwidth is being utilized at each node, and then for each network determining a user perceived data quality, like what is the perception of user for the data quality which he is experiencing by using that network, and then determining a utilization factor, and then based on all these factors a network is being selected. So basically it is about selecting one of those networks out of that. Now it is a method, it is not a category which the patent office can reject. It is a technical subject matter, but it was rejected because the person who drafted this patent applications, he never described what are the components or hardware components and what is the network which they are actually talking about. Everything was written in a way that it was solely based on selection of an access network, but specific details of how this method could be implemented or examples of an infrastructure was not described in the patent application. So the Indian Patent Office rejected this patent application by saying that whatever you are claiming is just a mathematical method. It does not enables anybody to implement this network by reading specific details which are required. So maybe the person would have described what all hardware components should be there, if there is a network interface card which should be there to support that network, what should be the configuration of that network interface card, where this method would run actually. So all those details were not described in the patent applications. Therefore, this patent was rejected. So even ideas which appear very technical get rejected by patent office, but that doesn't mean that all the ideas get rejected. There are certain requirements which are to be met and certain ideas which should be selected and filed for patent application. Okay, so this is a very simple example, I think, and this is a general exercise which is being performed by the patent examiner, and I've used this example to make people understand what the patent examiner do. So if you see, this is a claim, somebody filed a patent for a kettle. So this kettle has two spouts. So basically, he would have identified that, it takes a lot of time to, fill one cup and then fill another cup. So what he thought of that if I could have two spouts or output channels in this kettle, then I can simultaneously pour, coffee or tea into two cups at one go. He filed a patent application on it. Now, what an examiner would do, he would basically search what is there already existing, be it in research paper, be it in patent documents, be it in videos, be it in blogs. So he would do his own search to see if whatever somebody is trying to claim is already existing or not. Now, what does the examiner come across? He come across 4 documents. Now the first document talks about a simple teapot with one spout. Now this is different than what the individual is trying to claim. In his case, there are two spouts, two output channels, but in this there is only one spout. He came up with another document. If you see document 2, which is like a fertilizer distributor system, which has two output channels to distribute fertilizer. Then he come up with another document which talks about a coffee vending machine which has two output channels. And then he come up with another solution which is like a vinegar bottle, which basically which has two cylinders. I mean, two basically one bottle inside another bottle, and it is so smartly designed that if I pour from one channel, then whatever I pour would not get spilled out into another channel. It would drift into the first channel itself. Now, the examiner, when he looked at these documents, he said that whatever this person is trying to claim is pretty much obvious. Meaning that if any person who wants to develop, basically this sort of a kettle, he can look at these documents and then he can come up with this idea. So therefore, the examiner basically used multiple different documents and rejected his claim, saying that I can combine the teachings of these two ideas and come up with this solution. So this is another test which an individual has to do, and this is something which a person who does a patentability search checks. He checks not only for those documents which talk about exactly the same idea or exactly the same algorithm. He also checks if there are two documents which could be used together, and then he applies his own subject matter expertise to basically say that this patent may not, this case may not go through, for a success. So and then sometimes it is a very simple example, but sometimes the whatever you have filed as an idea, that technology is so much overlapping with the existing idea. Talk about neural networks, talk about machine learning algorithms. The difference, the technical difference would be just at one step or just at one neural layer of that networking model, or an activation function which you are using, or how you are using that activation function. So it is required to bring up that technical difference. Firstly, identify the technical difference, and then bring up that technical difference in a way that it shows that because of this technical difference, you are solving a big problem. And then you have to convince the examiner that because we are trying to claim and get patent just because of this technical difference. So that is also a job of individual who works in the field of patent. So I think I am done here. I'll stop here and I'll open the forum for questions.
Thank you so much, Sparsh. It was really an insightful session. Actually, when I really, if I express myself, I never thought that this would be too much informative session. And in detail, you have laid out action plan also for JKLU, and that looks very, actually, I would say that actionable and rewarding too. There are a few questions which let us answer first. How engineering graduates can build their career in IP? But that pretty much you have answered, I guess, in one of your slides. What are the main characteristics of a student who needs to build his or career in it? What are the career growth aspects? Growth aspects, I think you have already covered. I think you can focus on characteristic of a student, which he should have to pursue this kind of career.
Yes, so I think these are very relevant questions. So I think I discussed about characteristics. I'll just again go back there and try to highlight those characteristics. So yeah, so first and foremost characteristic should be that a student should have an engineering mindset. If he has interest in arts or humanities, or if he has interest in non-engineering and non-technical subject matters, then there is no point building a career in IT, because day in day out you have to deal with technology, and individuals get at a very early stage of their IP career, they get exhausted, because they have to read about so many technology, and sometimes they have to read so many research papers and documentation that they think that everything is same. They go into the phase which is called as paralysis of analysis. So you should enjoy reading technology, and you should enjoy reading about technical blogs, technical things. Engineering mindset should be there. The second characteristics is, as I told you, reading and writing ability to convince somebody with with data, with facts, ability to put things very clearly and concisely. Because you may be a recipient of a lot of data, be it from engineering focus, be it from inventors, be it from attorneys or lawyers, and then you have to process that data and you have to just come up with 3 points, which should be the outcome from your end, and you have to present those 3 points to a business head, and out of those 3 points he may totally discard those 2 points and he would focus on 1 point. So that is the level of conciseness which is required, to basically present your thoughts. That is another trait. And I think managing your work, timeline management, because I told you a lot of I told there are a lot of timelines, legal timelines are required, which are there. So a person needs to, it is not like a software development thing where nowadays many things are into DevOps and agile development is being there, but still people have at least 4 months time period that at the end of the 4 months we would be ready with the product. But in field of IP, the projects are of short timelines. You have 1 week timeline, or let's suppose 15 days timeline, and within that timeline sometimes another urgent project may come up and you have to switch between multiple priorities, and you cannot so you have to anticipate your work, and you cannot miss out on timelines because these are legal and statutory timelines. So if you miss out on that, sometimes you may lose up your patent rights. And these timelines are basically decided by the patent offices. That is another, I think, trait which should be there. And then I think the
grip
ability
on English language, I guess, isn't it? Or most of the patents.
Yeah, that is a foremost requirement. And particularly if you are doing patent drafting, then a very strong grip on English language is required. Because the difference between writing a patent application and writing a research paper is writing a patent application. It is very similar to writing research paper, because in the research paper also you are explaining your technology thinking. So you are not just explaining your invention or writing whatever you have worked on. You are sometimes thinking what your competitor company has similar to this. You are thinking in terms of what, if you will file this patent application, then what are the ways by which the competitor can work around on his product and get save himself from infringing on that product. So you have to think of all those possibilities which a competitor may adopt, to develop something which is very similar to your patenting idea, but still is different, and still you cannot file a licensing suit on or an enforcement suit on that. So a person who is writing a patent, he has to think about all those possibilities and cover those possibilities in the patent description.
Okay, two more questions are there in line. One is actually, what are the patent perspectives for mathematics people?
I think it is good. I mean, one thing which I have learned from my professional career in IP is, when you are in IP, you cannot use this excuse that I'm a software engineer, I am from computer science background, so I cannot work on a mechanical patent. You should be able to understand technology. You should prospects for mathematic based people are good, because I believe that people who are working on mathematics related stuff, they are good in data analysis, they are good in interpreting data, they are good in understand. There are a lot of recent technologies are based on a lot of mathematical algorithms and formulas. So I mean, he can solely adapt to it. But the bottom line is that student cannot use this excuse later on and say that I am from software field, so I cannot work on mechanical field, because generally the patents require cross collaboration and amalgamation of different technologies. Just as an example which I shared today, that inventory example, there were robots which involve electronics, mechanical operations. So within that patent, somebody has to describe how a robot works. He has to describe how the path planning of that robot is working. He has to describe how the end effector of that robot is working, and he has to also describe the image processing which is being done to identify different packets which are there in the inventory. So he may have to understand how a point cloud is being formed, and from that point cloud data different individual objects are being identified, and then how a robot is actually working on that individual objects. So people become technology agnostic after a period of time when they work in IP. But yes, I think for mathematical students it is also a promising.
Yeah, I think he's talking from another angle also. He being a professor of mathematics is talking about any filing of a patent or taking a grant of a patent
Yeah, so
as
from
a
that perspective,
mathematician.
I think if the idea is purely a mathematical formula, I would strongly recommend do not file a patent application because it would get rejected. So I discussed in my previous session under section 3K, I think subsection K, mathematical formulas per se are not patentable subject matter, but there is a way to get a patent on work you have done in field of mathematics. So assume that you have implemented an algorithm which involves mathematical formulas, but the end effect of that algorithm is actually some tangible effect. So let's suppose you worked on some, you use certain specific equations or mathematical formulas which improve the bandwidth utilization of a Flipkart website. Now that whole process is something which you
Is
can file a
mathematical.
patent application. Yeah.
True, true, true. Now, there's one interesting question from Gustavo, and I would say most of us might be having this. I feel this question is like man ki baat for everyone. Thank you for your session, Sparsh. How can we estimate the amount we get in case we win a patent infringement lawsuit?
So this is a very bomb level question, I would say, because there are different infringement suits. Uh, I shared few examples where $100 million were even given, but that doesn't mean that you developed a patent application and you filed an infringement suit against Google, because Google being such a big company, they would not even take care of that infringement suit. So uh, I'll tell you like how generally these things work. So universities, they generally do not go into patent enforcement activities, and even if they go for patent enforcement activities, the company to which they would send a letter that you are using our technology, that company would say that okay, tell us how much amount you want and we would acquire all of these patents. So money would be given. So really the case never goes to the court level. Even between companies, many big companies, the court generally out of court settlements are done. Where let's suppose if Microsoft says to Google that you are infringing on this set of patents, then Google would say that we also have a set of patents on which you are infringing. So let's do a sort of an out of court settlement. And there are a lot of strategies which are being adapted when doing all these talks. So it is like similar to when we used to see those Ramayana, where you have a lot of you have your whole armory, where you have a lot of different weapons, and you would initially use a weaker weapon, but at a later point of time you would use a stronger weapon. So the negotiation deal between the attorneys or lawyers of individual big companies would start from a very small amount. The company would say that we have just 5 patents and you are infringing on these patents, so either license it from us and give some amount, or you stop your production of this product. Then they would gauge that what that company is doing. That company would try to invalidate these patents. They would say that the patents you have, either they would pay the money, or they would say that the patents you have, these are invalid patents because of XYZ legal rules. So, and then this company, the first company, would come up with 20 more patents which are more powerful and stronger than so that is how, and then eventually they would come up with a trump card patent which would sort of do make the other company totally agree to the terms and conditions of the first company. So there are a lot of strategies which are involved. So the infringement case could go from $1 million to $100 million also, depending on how many, what stakes are actually involved.
So thank you so much, Sanjay sir.
Sparsh, I too have a question as usual, though
Yes.
I missed the first 20 minutes of your talk because there was a power failure here, and I couldn't. My network was also down, and I realized my phone was also discharged, so I had to move to a different place, and then I got connected. But I will listen to those missed minutes also. I'm very, very excited to. I have attended more than 1 hour of your session. It was very good session, very, very informative, and I agree with Sonal, very insightful also. My question is, this Qualcomm and Nokia initiative that you mentioned about for Indian startups and students, etc., is it in a specific area, or people can seek their support in any area?
So obviously, sir, it would be in a specific area. I know a little bit about Qualcomm one. I know that there is a concept by Nokia, but I have never explored it individually.
Okay.
But for I would say that what they do is that they generally so even in their objective they mentioned that you work on those ideas which are supported or which are connected to the let's suppose if they are manufacturing chips which are used, smart chips which are used in mobile devices. So if you are working on those specific related, or any sort of products in which Qualcomm is working, if your ideas are specific on those lines, then Qualcomm will collaborate and contribute. They encourage to file ideas from any domain, but generally those ideas are selected which on which Qualcomm team also can contribute.
Okay.
And evaluate their own solutions which they are developing. I mean, their objective is to evaluate their own prototypes or solutions which they are developing when they do this exercise.
Okay. And you gave a wonderful chart of the career growth path of the patent experts. Though about MNCs, I also have some information. But what is the situation with Indian companies? Are there any Indian companies other than maybe in the pharmacy sector or biotech sector who have that kind of a hierarchy of an IP expert going up to the director level and having a team at all at different levels? Are you aware of some such companies in India?
Yes. So yes, sir. So I think the in-house divisions, product in-house companies which I shared over here, most of these have all of these I have selected the ones only which have their in-house teams in India. And
but these are mostly MNCs. I'm talking of Indian.
Okay, I get it. So in specific Indian companies, like I would say, I am aware of. I think so. For example, Infosys, you can say as an example.
Infosys is again a multinational now. I mean, though it is India based, but it is a multinational now.
Yeah. Even TCS, I think TCS has their.
Yeah. So is the yeah. So I mean, in the conventional engineering sector, like Kirloskar or those kind of companies, do they have similar structure?
So I'll tell you. So they have first of all, the patent filing is little less. Like I know Intex is a speaker manufacturing company. They have their team. Kirloskar also have is there. Even I think this bike manufacturing company. I'm forgetting the name of that company.
Atlas or Hero?
TVS, I think.
Okay, TVS.
Hero also have their teams in India, but they are very small size teams, and the patent filing. I mean, the teams are not that big, and they also don't have very big patent portfolio. Which requires. So it could be a team of 10 people, and you are ahead. You can reach to be ahead of the team of 10 people. But the companies which I have mentioned over here, they have big teams. Like even 100 individuals, and not even patent team would be even for 100 individuals, but the engineering teams are into lakhs. So the exposure level is to very vast level of different teams which are working across different technologies.
Typically, in an IP company, which is mostly into IP creation, what is the ratio between the development engineer and the patent experts?
I think, sir, it could be probably 100:1.
Okay.
So one IP engineer has to act as an IP focal for a team of 100 engineers.
Okay. So this IT service companies that have lakhs of engineers should, if they were product companies, should have been having few thousand IP experts.
Yes, and generally the size of IP team is many companies generally outsource a lot of activities to these service industry companies.
Right.
And the IP team size is around 40 people, 50 people, or 100 people. They just hire very selected people who are 5 years or 6 years of experience in field of IP and who can drive the IP culture within the organization.
And you very rightly mentioned that one should be a voracious reader of the technology in order to get into this area. So just for the sake of the audience, how much did you read in your first year at CPA Global after your graduation?
So
when you joined,
I think, sir, because when I joined CPA Global, I was majorly working into performing patentability searches and learning patent databases and patent tools. So I was working on very basic projects which are generally there in the patent. So in a day, let's suppose if I have to prepare a patentability report in idea. So 2 days is something maybe which would be required to come up with an outcome. And in that 2 days, I have to come up with 8 to 10 patents, which I would have identified after analyzing, say, 100 or 150 patents, which basically are most closest to that idea. And then I have to give my opinion. So when I talk about 100 patent analyzing, within one day, let's suppose if you have to analyze 20 patents, or let's suppose 30 patents, it could be analyzing, reading claims and just reading background and watching figures, and then reading all the patents in entirety could be, like for a very specific, like out of those 100 patents, 20 patents you have selected, which you have to read in full entirety and understand it.
Yeah, very, very hard work. I'm sure that people would appreciate.
After a period of time, people develop this competency that they can read the patents very fast.
Yeah, that same is the case with research papers. So experienced researchers read research papers fast. New researchers have to take time. They should take time, which is fine. Same. Wonderful. Thanks a lot, Sparsh. It was really, really a wonderful session, and I'm sure we have already shared it on Facebook. And this should become useful to the larger community. Very, very informative. I don't think universities have arranged such kind of sessions which are so informative. Normally, sessions about patents do not go into so much of depth, and not by the patent experts themselves. So it would be very, very. I think your recorded video would reach out to lot more audience than we had in the session actually. I hope it happens quickly. And thank you very much. And yeah.
Thank you, sir. I just have one request. The digital platform which I talked about in this, I would really be happy if anybody can develop it, because based on my interaction with a lot of university people, they don't have any framework for patenting. It is more or less like that, students work with the mentors, and then mentors coordinate with some private firms. And
an idea is crossing my mind. I will talk to you after this. Maybe there is a need of a countrywide initiative in that regard, maybe an NGO or a countrywide initiative, because universities, small institutes would have smaller population who would be active. But if there can be a countrywide initiative where such a platform is made available to the interested inventors, through the support of some companies like yours or some CPU Global or some such companies could back it up by the intellectual support and maybe some investment. Maybe there is a need to have a countrywide platform available to any inventor. I think we should talk about that platform. Specific universities should certainly do, but I think there is a larger possibility here that I am seeing after listening to your talk.
Sure, sir. Sure.
Thank
you, sir.
Thank you.
Thanks a lot, sir. Thank you.
Thank you so much, Sparsh. Bye.
Bye. Bye. Stay safe.